If you're over 60 with significant retirement savings, you need to hear this. Only 5% of American seniors are using an asset protection strategy that could safeguard up to $234,000 of your wealth from unexpected costs and legal threats. Let me repeat that. 95% are missing out, often because they simply don't know it exists. In my 3 decades of guiding retirees, I've seen too many families devastated by a single lawsuit, nursing home bill, or financial misstep that could have been prevented. The wealthiest retirees I work with all share one thing in common. They take steps to protect what they've earned, not just grow it. This is educational content designed to help you make informed financial decisions. Always consult a qualified financial advisor for your unique situation. And remember, past performance doesn't guarantee future results. Today, I'm going to reveal exactly how this overlook strategy works, who qualifies, and the simple steps you can take to shield your assets, potentially saving your family hundreds of thousands of dollars and giving you true peace of mind. What you're about to discover could change the way you think about retirement security forever. But first, let me share the most important detail every retiree needs to know. Part 1. The hidden threat to your retirement nest egg. Let's start with a reality that far too many retirees only recognize when it's too late. Your hard-earned nest egg is more vulnerable than you think. After working for decades, saving, investing, and making smart choices, you expect those assets to provide comfort, security, and dignity in retirement. But there's a silent risk that threatens to undo all your careful planning, and it's one that most financial advisors barely mention, if they mention it at all. In my 30-plus years of helping American seniors navigate retirement, I've seen this scenario play out hundreds of times. A couple retires with a solid portfolio, maybe $650,000 in 401ks and IRAs, a home worth $350,000, and another $50,000 in savings. They feel secure. But then something happens. A lawsuit, a medical event, or even a simple mistake in paperwork. Suddenly, the assets they spent a lifetime building are exposed, and what should have been a legacy for their family is at risk of vanishing. Let me share a few numbers that might surprise you. According to the U.S. Department of Health and Human Services, nearly 70% of Americans over age 65 will need some form of long-term care. The median annual cost of a private room in a nursing home? Over $108,000 as of 2023. That means just 2 years in care could drain $216,000 from your accounts. And Medicare, as many retirees discover too late, typically covers little to none of these costs. But that's not the only threat. Legal actions against seniors are rising, whether it's from a car accident, a fall on your property, or even a disgruntled relative contesting your estate. In fact, the National Council on Aging reports that seniors lose an estimated $2.9 billion each year to exploitation, scams, and legal disputes. Let me repeat that. Nearly $3 billion evaporates from seniors' accounts every year, often because their assets aren't properly protected. Now, you might be thinking, that won't happen to me. I'm careful. I have insurance. And I understand that mindset. After all, you've spent your life being responsible and prudent. But here's the uncomfortable truth. Most insurance policies have strict limits and exclusions. For example, umbrella liability coverage may cap out at $1 million, and many policies don't cover the full spectrum of risks that retirees face today. Even a single uncovered event, a lawsuit that exceeds your policy limits, or a long-term care need that isn't fully insured, can quickly eat through your savings. What's even more concerning is how few people are taking real action to guard against these dangers. According to a 2022 AARP survey, less than 5% of seniors have implemented comprehensive asset protection strategies beyond basic insurance and wills. That means 19 out of 20 retirees are leaving hundreds of thousands of dollars exposed, often without even realizing it. Let's put this into perspective. Imagine you've built up $700,000 in retirement assets. If you're like most, you assume those funds are safe, earmarked for travel, health care, and passing on to your loved ones. But a single uncovered event, say a nursing home stay or a successful lawsuit, could wipe out $234,000 or more in less than 2 years. That's not just a statistic. I've seen it happen to families who never expected to be in that position. And the risk increases as you age. After 60, the odds of facing a health crisis, a legal challenge, or even falling victim to financial exploitation rise dramatically. Scammers specifically target retirees, knowing that you have accumulated assets and may be more trusting. According to the FBI, seniors lose an average of $34,200 per scam, sometimes much more if their accounts aren't properly shielded. But here's what most financial advisors won't tell you. The traditional approach, relying solely on insurance, basic wills, and hope, leaves gaping holes in your financial defenses. The most successful retirees I work with understand that true security requires more than just growing your money. It's about protecting what you've already earned. And the window to put these protections in place narrows as you get older, especially when health or legal issues arise. Now, I want to be absolutely clear. This is educational content, not personalized financial advice. Your situation is unique, and you should always consult with a qualified financial advisor before making any changes to your financial plan. I'm sharing these insights based on my decades of experience working with retirees just like you, so you can make more informed decisions about your future. Let me repeat the most important point so far. Fewer than 5% of seniors have real effective asset protection in place. That means 95% are exposed to threats that could erase $234,000 or more of their retirement savings. Every year you wait to address this risk, the odds of a costly event increase and your options for protection may shrink. The sooner you take action, the more you can safeguard your legacy and your peace of mind. So far, we've covered the hidden vulnerabilities facing retirees, the shocking statistics about long-term care costs and legal risks, and the reality that most people are leaving their life savings exposed. But there's one critical issue that could derail everything. Most seniors don't realize that comprehensive, proven asset protection strategies even exist, let alone how accessible and effective they can be. But here's the insider secret that changes everything. Part 2. The core solution. How strategic asset protection shields your retirement. Now that you understand the real risks threatening your retirement nest egg, it's time to talk about the solution that only 5% of American seniors are actually using. A solution that can protect up to $234,000 or even more from lawsuits, long-term care costs, and unexpected financial threats. In my 30-plus years of guiding retirees through the maze of asset preservation, I've seen firsthand how this single strategy can mean the difference between a secure retirement and a devastating loss. And yet, most people never hear about it until it's too late. Let me say this clearly, the foundation of true retirement security isn't just about growing your money. It's about making sure what you've earned is protected from every angle. That's why the most successful retirees I work with use a combination of legal structures and financial planning tools, not just basic insurance or a simple will. The core strategy I'm talking about is the use of specialized asset protection trusts, sometimes called irrevocable trusts or Medicaid asset protection trusts, combined with a carefully sequenced legal and financial plan. Let me repeat that important point. An asset protection trust is not the same as a standard revocable living trust. While a living trust can help your estate avoid probate, it doesn't shield your assets from lawsuits, creditors, or the high cost of long-term care. An asset protection trust, on the other hand, is specifically designed to move your most vulnerable assets, like your home, investment accounts, or even a portion of your IRA, out of your personal ownership, so they can't be targeted by lawsuits or nursing home bills while still allowing you to benefit from those assets during your lifetime. Now you might be thinking, isn't that complicated or risky? Here's what I've seen over the decades. When set up properly, with the help of a qualified elder law attorney and a credentialed financial advisor, these trusts have a 40-plus year track record of protecting assets for seniors across the country. Industry insiders know that wealthy families have been using these tools for generations, not to hide money, but to ensure that what they've earned supports their own needs and their loved ones, not creditors or the government. Why does this work so well for seniors, especially those over 60 with substantial retirement savings? It comes down to two key reasons. First, the law treats assets inside an irrevocable trust differently than assets held in your own name. For example, if you transfer your home into a properly structured asset protection trust and you do so at least 5 years before applying for Medicaid, that home is typically not counted as an available asset. That means if you need long-term care, you could potentially qualify for government assistance without having to spend down your house or deplete your savings. The same applies to certain investment accounts and even cash reserves. When moved into the right trust, they're shielded from lawsuits and creditors too. Second, these trusts are designed with flexibility in mind. You can still receive income generated by the assets in the trust, and you can set clear instructions for how those assets are used for your benefit while you're alive. When you pass away, your heirs can receive the assets directly, often avoiding probate and minimizing estate taxes. And because the trust is irrevocable, it's much harder for anyone to challenge your wishes or force the sale of your property to pay off a lawsuit or nursing home bill. Let me share two brief success stories, real situations I've seen, though I'll keep names confidential to respect privacy. The first was a retired teacher and her husband, both in their early 70s with about $400,000 in retirement savings and a home worth $250,000. They were worried about the rising cost of health care and what might happen if one of them needed nursing home care. Working with their attorney and financial advisor, they set up an asset protection trust and moved their home and $200,000 of their savings into it. 5 years later, the husband required full-time care. Because the assets were inside the trust, they were able to qualify for Medicaid without losing their home or their retirement savings. The trust protected over $300,000, money that would have been at risk if they'd done nothing. The second story is of a widowed engineer in his late 60s who had accumulated about $600,000 in a 401k and $100,000 in a Roth IRA. He was concerned about potential lawsuits. He'd heard stories about neighbors being sued for accidents on their property. By working with an estate planning attorney, he was able to transfer the family home and a portion of his non-retirement savings into an asset protection trust. A few years later, a legal dispute did arise, but because his most valuable assets were shielded, he was able to settle the matter quickly and avoid a costly court battle. The trust protected nearly $250,000, ensuring his children would inherit what he'd worked so hard to build. I want to pause and emphasize, this is educational content, not personalized financial advice. Your circumstances are unique, and you must consult with a qualified financial advisor and an experienced elder law attorney before making any changes to your estate plan. But what I can tell you, after decades in this field, is that the retirees who take action, who use proven conservative strategies like asset protection trusts, are the ones who sleep best at night. They know their assets are protected, their wishes will be honored, and their families won't face unnecessary hardship. So, why don't more people use this strategy? In my experience, it's not because they don't care. It's because they've never been told about it, or they assume it's only for the ultra-wealthy. The truth is, anyone with $200,000 or more in savings, a paid-off home, or significant retirement accounts can benefit from this approach. It's a safety-first method that's been quietly used by affluent retirees for decades, but it's just as valuable for middle-class families who want to make the most of what they have. Let me recap what we've discussed so far. We've identified the real risks, lawsuits, long-term care, and exploitation that threaten your retirement assets. we've seen how less than 5% of seniors use asset protection trusts, even though these strategies have a long, proven track record. And we've looked at real-world examples of retirees who protected hundreds of thousands of dollars using these legal tools. The sooner you implement a strategy like this, the more options you have, and the more you can protect. Now, you might be wondering, how exactly does this process work? What steps do I need to take to put this protection in place for my own family? That's what we'll cover next. I'll walk you through the exact implementation steps with clear numbers, timeframes, and practical guidance so you can move forward with confidence. The solution is simpler than you think, but most people get it wrong. Now, let me show you exactly how to implement this. Part 3. Step by step, how to put $234,000 of your assets beyond reach. Now that you understand the power of asset protection trusts and why they're so effective for retirees, let's get practical. I want to walk you through the exact steps you can take to shield your retirement nest egg, potentially up to $234,000 or more, from the kinds of risks we've discussed. Remember, this is educational content, not personalized financial advice, and your unique situation deserves a tailored approach with a qualified financial advisor and an elder law attorney. But after 30-plus years of helping seniors safeguard their wealth, I can tell you that these proven steps are what the most successful retirees follow. Let's begin with the foundation: timing. The sooner you start, the more protection you'll have. Many retirees wait until a health scare or legal issue arises, but by then, options are limited, and the 5-year look-back period for Medicaid asset protection may already be working against you. Every month you delay could cost you thousands in lost protection, so it's wise to act while you're healthy and your finances are in order. Step 1 is to take a full inventory of your assets. This means gathering up-to-date statements on your 401ks, IRAs, Roth IRAs, brokerage accounts, bank accounts, and the current value of your home and any other real estate. For most retirees I work with, this totals between $400,000 and $1.2 million. Don't forget to include life insurance cash values and any valuable personal property worth over $5,000. Write down the account numbers, balances as of today, and whether each asset is titled in your name, jointly, or in a trust already. This process usually takes a week or two, depending on how organized your paperwork is. Let me repeat. A complete and accurate inventory is the foundation for every other step. Step 2 is to schedule a consultation with a qualified elder law attorney who specializes in asset protection trusts. Not every attorney has the right experience. Look for someone with at least 10 years of focused practice and ask specifically about Medicaid asset protection, irrevocable trusts, and estate planning for retirees. Expect to spend $300 to $600 for an initial consultation, which is a wise investment considering the stakes. Bring your asset inventory with you. In my experience, this meeting typically lasts 60 to 90 minutes and will clarify which assets can be protected, what the process will look like, and what your options are. Step 3 is to decide which assets you want to move into the Asset Protection Trust. Most seniors choose to protect their primary residence, often valued between $150,000 and $400,000, and a portion of their liquid savings or non-qualified investment accounts, usually $50,000 to $250,000. Retirement accounts like 401ks and traditional IRAs are more complex due to tax rules, but Roth IRAs and after-tax brokerage accounts can often be included. Your attorney will walk you through the implications. The key is to focus on assets that are most vulnerable to lawsuits, long-term care costs, and probate. This step is where you'll make the biggest impact on your family's future. Step 4 is the actual creation and funding of the trust. Your attorney will draft the trust documents. This can take 2 to 4 weeks. Once the trust is signed and notarized, you'll need to retitle your home and transfer selected accounts into the trust's name. For a home, this means preparing a new deed, which your attorney will file with your county recorder's office. For investment accounts, you'll work with your financial advisor or the institution's trust department to complete the paperwork. This process may take another 30 to 45 days, depending on how quickly institutions process trust transfers. Let me emphasize, this is the step where many people get stuck, so having an experienced attorney and a proactive financial advisor is critical. Step 5 is to update your beneficiary designations and estate plan to coordinate with your new trust. This is a detail that many retirees overlook, but it's essential for maximizing protection and minimizing taxes. For example, you may need to update the beneficiaries on your IRAs, 401ks, and life insurance policies to ensure they align with your trust and overall wishes. This step usually takes 1 to 2 weeks, but can save your heirs months of legal headaches and thousands in unnecessary taxes or probate fees. Let's recap the timeline. Taking inventory, 1 to 2 weeks. Attorney consultation, 1 week to schedule, 1 to 2 hours for the meeting. Trust drafting and signing, 2 to 4 weeks. Transferring assets, 30 to 45 days. And updating beneficiaries, 1 to 2 weeks. Altogether, you can have your protection in place within 60 to 90 days if you're proactive. Now, I know what you might be thinking. What about the costs? Setting up an asset protection trust typically ranges from $3,000 to $7,500 in legal fees, depending on complexity and your location. Compare that to the risk of losing $234,000 or more to a single lawsuit or 2 years of long-term care, and you can see why the most successful retirees view this as a wise investment. There may also be small county filing fees, usually under $500, and possible costs for retitling investment accounts, often waived by larger institutions. The key is to ask for a written fee agreement up front and to understand exactly what's included. Of course, every retiree has unique concerns, and I've heard them all over the years. Some worry about losing control of their assets. The truth is, with most asset protection trusts, you retain significant control. You can live in your home, receive income from investments, and set the rules for how the trust operates. Others worry about tax implications. Properly structured, these trusts usually preserve your property tax exemptions and allow your heirs to receive a step-up in basis, minimizing capital gains taxes. And for those concerned about qualifying for Medicaid, the 5-year look-back period is critical. Assets transferred into the trust less than 5 years before applying for benefits may still be counted, so timing matters. Let me repeat that important point. The 5-year window is not just a guideline, it's a hard rule for Medicaid eligibility. If you transfer assets into a trust today, they're generally protected from nursing home spend-downs after 5 years. That's why acting sooner rather than later is so important. Every month you wait, you push that protection further into the future. So far, we've covered how to gather your financial information, find the right legal expertise, choose which assets to protect, complete the transfer process, and coordinate your overall estate plan. These are the same steps I've seen thousands of retirees follow to shield their homes, savings, and investments for themselves and their families. But before you take action, you need to avoid these critical mistakes, errors that can cost you tens of thousands and undo all your careful planning. Even the best strategies can backfire if you miss these pitfalls, and unfortunately, I've seen too many well-meaning retirees fall into these traps. Before you do anything, avoid this costly mistake. Part 4. Common Mistakes and Pitfalls. How to avoid losing your protection and your peace of mind. Let's pause for a moment. You've seen how powerful asset protection trusts can be, and you're starting to understand the specific steps to put this $234,000 shield in place. But after 30-plus years of helping retirees through these transitions, I can tell you, the biggest losses don't come from not acting. They come from acting without the right guidance or missing a crucial detail. Even the most well-meaning, careful seniors can stumble into expensive traps if they're not aware of the risks. This is educational content, not personalized financial advice, and you should always consult with a qualified financial advisor and elder law attorney before making decisions. Let me walk you through the most common and costly mistakes I've seen so you can protect yourself and your family from heartache and financial loss. The first mistake is failing to start the process early enough. Many retirees wait until a health scare or legal threat is already on their doorstep. I can't tell you how many times I've received a call from a family in crisis. Maybe a spouse is suddenly admitted to a nursing home, or a lawsuit is filed after an accident, and they want to move assets into a trust overnight. Here's the harsh reality. Medicaid's 5-year look-back rule is strictly enforced. If you transfer your home or savings into an asset protection trust less than 5 years before applying for Medicaid, those assets can still be counted, and you may be required to spend down or even face a penalty period. I've seen families lose $150,000, $200,000, even their entire home value because they waited too long. The warning sign here is procrastination. If you're thinking, "I'll get to it next year," remember that every month you delay is another month of exposure. The sooner you act, the more options you have, and the greater your peace of mind. The second expensive mistake is choosing the wrong type of trust or using a generic online template. I've seen retirees try to save money by downloading irrevocable trust forms from the internet or working with attorneys who don't specialize in elder law. The result? Trusts that don't meet Medicaid requirements, don't protect against lawsuits, or even worse, trusts that accidentally trigger gift taxes or disqualify you from important tax benefits. One client I worked with had set up a trust online thinking they were protected, only to discover during a Medicaid application that their $320,000 home was still considered a countable asset. The cost? They had to spend down nearly $100,000 before qualifying, and their heirs lost the step-up in basis, resulting in thousands in unnecessary capital gains tax. The warning sign here is any trust that isn't specifically drafted by an elder law attorney with deep experience in your state. If it sounds too simple or too cheap, it probably is. The third pitfall is failing to properly fund the trust. Setting up the legal paperwork is just the beginning. If you don't retitle your home, transfer your investment accounts, or update your beneficiary designations, your assets remain exposed. I've seen seniors pay $5,000 or more for a beautifully drafted trust, only to leave their home titled in their own name or forget to move $100,000 in savings into the trust. When the time comes, those assets are still vulnerable to probate, lawsuits, or Medicaid spend-down. The financial cost? I've witnessed families lose $234,000, the very amount they thought was protected, simply because the paperwork wasn't finished. The warning sign here is any lingering to-do items after your trust is created. If your home deed, bank accounts, or brokerage accounts don't list the trust as the owner, you're not protected. A fourth and increasingly common mistake is failing to update your trust and estate plan as your life changes. Laws shift, family situations evolve, and your asset mix will change over time. I've seen retirees set up a trust at age 62, then forget about it for a decade. By the time they need care or pass away, new laws have taken effect, or their assets have grown far beyond the original plan. In one case, a retiree's trust didn't account for a new grandchild, and state tax law changes meant their heirs lost out on $28,000 in tax savings. The warning sign here is a set-it-and-forget-it mentality. Your trust and estate plan should be reviewed every 2 to 3 years, or whenever you experience a major life event, such as marriage, divorce, a new grandchild, or the sale of your home. Let me recap the most expensive mistakes: waiting too long and missing the 5-year window, using the wrong trust or a generic template, failing to fully fund the trust, and neglecting to update your plan as life changes. Each of these can cost you not just money, but the very security and peace of mind you're working so hard to achieve. In my decades of working with retirees, I've seen these pitfalls lead to losses, ranging from $15,000 in unnecessary taxes to over $250,000 in lost home equity or savings. The most successful retirees I know are those who take a safety-first approach, double-check every detail, and work with qualified professionals every step of the way. Before we move on, let me repeat. This is educational content, not personalized financial advice. The risks and solutions we've discussed are based on years of experience and historical outcomes, but your situation is unique. Always consult with a qualified financial advisor and elder law attorney to ensure your plan is right for you and your family. Now, here's the good news. Once you avoid these traps, you can access advanced strategies that most people never learn. Techniques that optimize your protection, minimize taxes, and help you leave a stronger legacy for your loved ones. Most retirees stop at the basics, but the next level is where you truly maximize the benefits of your asset protection plan. Once you avoid these traps, you can access advanced strategies that most people never learn. Part 5. Advanced Strategies and Optimization. Unlocking the full potential of your asset protection. Now that you know how to avoid the most expensive mistakes and you understand the importance of getting the basics right, it's time to look at the advanced strategies that can truly set your asset protection apart. In my 30-plus years of guiding retirees, I've seen that the most successful and secure families are the ones who don't just stop at the minimum. Instead, they ask, how can I maximize every benefit, protect every dollar, and leave the strongest possible legacy? If you're watching this, you're already ahead of 95% of American seniors. But let's take it to the next level. As always, let me remind you, this is educational content, not personalized financial advice. Your specific situation deserves the attention of a qualified financial advisor and an experienced elder law attorney. What I'm sharing comes from decades of experience and the best practices used by affluent retirees across the country. The first advanced technique is layering your asset protection trust with a tax-efficient withdrawal strategy. Many retirees don't realize that the way you sequence withdrawals from your 401k, Roth IRA, and taxable accounts can make a difference of tens of thousands of dollars over your retirement. Here's how the most successful retirees approach it. Once you've transferred your home and non-qualified investment accounts into the trust, you work with your advisor to coordinate withdrawals in a way that minimizes your annual tax bill and maximizes your after-tax cash flow. For example, let's say you have $300,000 in a traditional IRA, $100,000 in a Roth IRA, and $200,000 in a brokerage account now protected by your trust. Historically, many retirees have withdrawn from their taxable accounts first, then their IRAs, saving Roth IRAs for last. But with the right planning, you might blend withdrawals, taking enough from your IRA to stay in the 12% tax bracket, up to $94,300 for married couples in 2024, then supplementing with tax-free Roth distributions or trust income. This approach can reduce your lifetime tax bill by $25,000 to $50,000 while keeping your taxable income low enough to avoid higher Medicare premiums and the 3.8% net investment income tax. The key is to review your withdrawal plan every year, especially as tax laws and your income needs change. The second advanced strategy is integrating your asset protection trust with your Social Security optimization plan. I've seen thousands of seniors make the mistake of claiming Social Security too early, leaving up to $180,000 on the table over a 20-year retirement. But when you coordinate your trust income with a delayed Social Security strategy, you can often replace income needs with trust distributions or tax-efficient withdrawals, allowing you to defer your Social Security benefit until age 70. This can increase your monthly payment by up to 77% compared to claiming at 62. For a retiree who would receive $2,000 per month at full retirement age, waiting until 70 could boost that benefit to over $3,500 per month. an extra $18,000 per year for life. By bridging the gap with protected trust income, you not only safeguard your assets, but also maximize your guaranteed inflation-adjusted income for the rest of your life. The third sophisticated technique is using your asset protection trust as a tool for multi-generational estate planning and tax savings. Many retirees don't realize that with the right trust structure, you can set up your assets to pass directly to your children or grandchildren, bypassing probate and often reducing or even eliminating state estate taxes. For example, some states still impose estate taxes on estates over $1 million. If your home, investments, and life insurance add up to more than that, your heirs could face a tax bill of $30,000, $50,000, or more. By including testamentary provisions and generation skipping features in your trust, you can direct assets to your grandchildren, provide for special needs beneficiaries, or even fund a family education trust, all while keeping these assets protected from creditors, divorces, and lawsuits. Let me give you a real-world example based on what I've seen with clients over the years. One couple, both retired engineers, had about $800,000 in combined assets and wanted to help their grandchildren with college costs. By working with an experienced attorney, they set up their asset protection trust to include a subtrust for education. When they passed, $150,000 flowed directly to that subtrust, bypassing probate and state estate taxes, and was protected from any potential lawsuits against their children. Their grandchildren received $10,000 per year for tuition, tax-free, while the rest of the assets continued to grow for the next generation. The family saved over $42,000 in probate fees and taxes, and the assets remained out of reach from creditors and divorces. Another advanced optimization is reviewing your trust's investment allocation. Too often, retirees put all their trust assets in ultra-conservative accounts, missing out on growth. The wealthiest retirees I work with use a balanced, risk-managed approach, keeping enough in cash or short-term bonds for 5 years of distributions, but investing the rest in a diversified portfolio of blue-chip stocks, high-quality municipal bonds, and even inflation-protected securities. Historically, this approach has provided 4% to 6% annual growth, helping the trust keep pace with inflation and ensuring there's more for your heirs. Remember, your trust can be both a shield and a growth engine, if managed wisely. Of course, tax implications are always front and center. With the right planning, you can ensure that your heirs receive a step-up in basis on inherited assets, wiping out capital gains tax on decades of appreciation. For example, if you bought your home for $80,000 and it's now worth $300,000, your heirs could avoid capital gains tax on that $220,000 gain if the trust is structured correctly. But get it wrong, and they could face a tax bill of $40,000 or more. That's why it's so important to work with professionals who understand both the legal and tax aspects of advanced asset protection. Let's recap. We've covered how to coordinate your trust with tax-efficient withdrawals to save $25,000 to $50,000 in taxes, how to use trust income to optimize your Social Security and add up to $18,000 per year to your guaranteed income, and how to structure your trust for multi-generational estate planning, saving your heirs tens of thousands in taxes and legal fees. We've also touched on the importance of investment management inside your trust and the critical tax rules that can make or break your plan. Once again, this is educational content, not personalized financial advice. Always consult a qualified financial advisor and an elder law attorney to ensure these advanced strategies are implemented correctly for your unique needs. The key to success is getting your timing exactly right. When you coordinate these advanced moves in the proper sequence, you unlock benefits that most retirees never even imagine. But what does that timing look like in practice? How do you know what to do first, second, and third, and what deadlines you can't afford to miss? The key to success is getting your timing exactly right. Part 6. Implementation Timeline and Sequence. Your 90-day roadmap to asset protection. Let's bring all these strategies down to earth and walk through exactly how you can put this asset protection plan in place, step by step, with real-world timelines and important dates to keep you on track. Over the last 3 decades, I've seen that the retirees who succeed are the ones who approach this process with both urgency and a clear sequence. They don't rush blindly, but they also don't let months slip by while their assets remain exposed. This is educational content, not personalized financial advice, and you should always consult with a qualified financial advisor and elder law attorney to tailor this plan to your unique situation. But if you're ready to take action, here's a proven 90-day roadmap that can help you protect up to $234,000, or even more, before the next big risk comes knocking. Let's start with the first 30 days. This is your information gathering and team building phase. During this time, your primary goal is to get organized and assemble the right professionals. In my 30-plus years of helping retirees, I've found that the most successful clients dedicate the first week to pulling together all their financial statements: 401ks, IRAs, Roth IRAs, brokerage and bank accounts, life insurance, and of course, your most recent home value assessment. Make sure you also have copies of your most recent will, power of attorney, and any existing trust documents. This inventory process usually takes 1 to 2 weeks, depending on how organized your records are. The warning sign here is letting paperwork pile up. Set aside an hour each day, and by the end of 2 weeks, you'll be amazed at how much you've accomplished. By week 2 or 3, you should be researching and interviewing elder law attorneys. The ideal professional has at least 10 years of experience with asset protection trusts and Medicaid planning. Call at least 2 or 3 offices, ask for a fee schedule in writing, and schedule your initial consultation. Most attorneys can see you within 2 weeks, but if you're in a high-demand area, book as soon as possible to avoid a backlog. During this meeting, you'll bring your asset inventory and discuss your goals. Expect to spend $300 to $600 for this first appointment, which is a small price for the peace of mind it brings. If you already have a trusted financial advisor, now is the time to loop them in, so everyone is on the same page. By the end of the first 30 days, you should have a clear action plan from your attorney, including which assets to protect, which trust structure is best for you, and a written estimate of legal fees and timelines. Let me repeat that. You want a written summary and a checklist of next steps before moving forward. This is your foundation for everything that follows. Moving into days 31 through 60, you're now in the trust creation and funding phase. Your attorney will draft your asset protection trust, which usually takes 2 to 4 weeks, depending on complexity and their current caseload. During this time, your job is to gather any additional documents the attorney requests: deeds to your home, recent investment statements, and copies of any beneficiary designations. If you're married, both spouses should be involved in every conversation. The most successful retirees I work with keep a dedicated folder, physical or digital, for all trust-related paperwork, so nothing gets lost. Once the draft is ready, you'll review it with your attorney and financial advisor. Don't rush this step. Take a few days to read through the documents, ask questions, and make sure you understand how the trust will operate. The goal is to sign and notarize the trust by day 60. Many attorneys will schedule a signing appointment and handle all notarization in their office, so you leave with official copies in hand. Immediately after the trust is signed, you move into the asset transfer process. For your home, the attorney will prepare a new deed transferring ownership to the trust and file it with your county recorder. This can take anywhere from a few days to a couple of weeks, depending on local government processing times. For investment accounts, you'll work with your financial advisor or the institution's trust department to complete transfer paperwork. This is often the step that takes the most follow-up. Some banks and brokerages move quickly, while others may need several reminders. A good rule of thumb: set calendar reminders every 5 days to check in on the status of each transfer. The most successful retirees I've worked with stay persistent and keep detailed notes of every call or email. By the end of day 60, your trust should be signed, and most, if not all, asset transfers should be underway. Don't worry if a few accounts are still in process, but follow up until you receive written confirmation that each asset is titled in the name of your trust. Let me repeat, your protection is only as strong as your paperwork. If your home, savings, or investment accounts are still in your personal name, they remain exposed. Now let's talk about days 61 through 90. This is the optimization and coordination phase. Once your assets are transferred, it's time to update all beneficiary designations on your IRAs, 401ks, Roth IRAs, and life insurance policies to ensure they align with your new trust and estate plan. This process usually takes 1 to 2 weeks, but it's crucial for avoiding probate and ensuring your wishes are honored. Review your Social Security claiming strategy with your financial advisor now that you have trust income options. If you're considering delaying Social Security to maximize your monthly benefit, this is the time to map out how trust distributions or tax-efficient withdrawals can fill the gap. Next, revisit your healthcare directives, power of attorney, and any previous will to make sure everything coordinates with your new trust. The most successful retirees schedule a 30-minute review with their attorney and advisor to confirm that every document is up to date. If you've included advanced strategies, such as sub-trusts for grandchildren, charitable giving, or tax-optimized withdrawal plans, this is when you finalize those details. By day 90, you should have a complete, coordinated plan that protects your assets, minimizes taxes, and ensures your family's future. Along the way, keep an eye out for important deadlines. If you're planning to apply for Medicaid in the next 5 years, mark the date of your asset transfers. Assets moved into the trust before this date will be protected after the 5-year look-back period. If you're updating beneficiary designations, confirm with each institution that your changes are processed and reflected in your account statements. And if you experience any major life changes, marriage, divorce, a new grandchild, or the sale of a home, schedule a review with your attorney within 30 days to keep your plan current. Let's quickly recap the timeline. First 30 days. Gather records, assemble your team, and create your plan. Days 31 to 60. Draft and sign the trust, transfer assets, and follow up on paperwork. Days 61 to 90. Update beneficiaries, coordinate your estate plan, and finalize advanced strategies. By the end of 90 days, you'll have moved from exposed to protected with a plan that can shield $234,000 or more of your retirement nest egg from lawsuits, long-term care costs, and probate. You'll also be in position to optimize Social Security, minimize taxes, and leave a lasting legacy. But even with the best plan and timeline, real life sometimes throws a curveball. You might run into delays, questions, or unexpected complications. That's why it's so important to know what roadblocks you might face and how to overcome them before they threaten your protection. Even if you follow this perfectly, you might encounter these common roadblocks. Part 7. Troubleshooting and Problem Solving. Navigating the real-world hurdles of asset protection. Let's take a moment to acknowledge something important. Even with the best-laid plans, the road to protecting your assets is rarely perfectly smooth. In my 30-plus years helping retirees secure their nest eggs, I've seen just about every challenge you can imagine, and I've helped clients work through each one. This is educational content, not personalized financial advice, and you should always consult a qualified financial advisor and elder law attorney for your unique situation. But I want you to know, if you hit a roadblock, you're not alone, and there are proven solutions that can keep your plan on track. Let's start with one of the most common issues: delays in asset transfers. You've done the work, your trust is signed, Your attorney has prepared the new deed for your home, and you've submitted paperwork to your bank or investment firm. But weeks go by, and your accounts still aren't showing the trust as the owner. This can be incredibly frustrating, and I've seen it happen with both large and small institutions. The risk here is that as long as assets remain in your personal name, they're still exposed to lawsuits, probate, and spend down for long-term care. Here's how to handle it. First, don't assume the paperwork is being processed unless you have written confirmation. The most successful retirees I work with keep a detailed log, dates of submission, names of representatives spoken with, and follow-up dates. If you haven't received confirmation within 10 business days, call the institution directly and ask for a status update. If you're told there's a missing document or signature, get clear instructions and resubmit promptly. In my experience, persistence pays off. If you're still running into delays after 30 days, ask your attorney or financial advisor to intervene. They often have direct contacts in trust departments and can escalate your request. Let me repeat, until you have written confirmation that your assets are titled in the trust, your protection isn't complete. Another challenge I see often is confusion about tax implications, especially when moving assets into a trust. Many retirees worry, will I trigger a big tax bill by transferring my home or investments? The good news is that, when structured properly, an asset protection trust is designed to avoid immediate capital gains taxes and typically preserves your property tax exemptions. For example, if you transfer your primary residence into the trust, you should retain your homestead exemption and any senior property tax benefits, but you must file updated paperwork with your county. If you're transferring appreciated stocks or mutual funds, make sure the trust is structured to allow your heirs a step up in basis when you pass. This can save them tens of thousands in capital gains tax. If you're unsure, ask your attorney for a written summary of tax consequences and review it with your advisor. In my experience, clarity up front prevents costly surprises down the road. Let's talk about another frequent roadblock: family disagreements or misunderstandings. Sometimes adult children or other heirs may not understand why you're setting up an asset protection trust, or they may worry about losing access to assets. In some cases, siblings may disagree about who should serve as trustee or how assets will be distributed. I've seen these situations cause unnecessary stress and even legal disputes, especially if communication is lacking. Here's what works. Hold a family meeting, ideally with your attorney or advisor present, to explain your goals and how the trust works. Emphasize that the purpose is to protect family wealth from outside threats, not to cut anyone out or create secrecy. Share as much information as you're comfortable with and make it clear that you're following a proven, safety-first approach that's protected thousands of families just like yours. If you anticipate ongoing conflict, consider appointing a neutral third-party trustee, such as a bank or professional fiduciary, to manage the trust and avoid family friction. In my experience, open communication and professional guidance turn potential conflicts into collaboration. Now let's address a scenario that catches some retirees off guard. What if you need access to the assets in your trust for an unexpected emergency? The most common fear I hear is, if I put my home or savings in a trust, can I still use them if I need cash for a medical crisis or major home repair? The answer depends on how your trust is structured, but here's what I've seen work best. In most properly drafted asset protection trusts, you retain the right to live in your home and receive income from trust investments. If you need to sell your home, the trust can do so, and the proceeds remain protected within the trust. For liquid assets, you may be able to receive distributions according to the trust's terms, but you cannot simply withdraw principal at will. This is what provides the legal protection. The key is to work with your attorney to build in flexibility for emergencies, such as allowing limited distributions with trustee approval. If you anticipate needing more access, discuss this at the outset so your trust can be tailored to your needs. Another what-if scenario that comes up: What if laws change after you set up your trust? Over the years, both federal and state regulations around Medicaid, estate taxes, and asset protection have evolved. I've seen clients who set up trusts under one set of rules, only to have new laws affect their eligibility or tax treatment. The solution is regular reviews, at least every 2 to 3 years, or whenever there's a major legal change. Your attorney should offer periodic check-ins, and your financial advisor can flag new legislation that may affect your plan. The most successful retirees I know treat their trust as a living document, updating it as laws and life circumstances change. Let's recap the most common implementation challenges: delays in asset transfers, confusion about tax consequences, family disagreements, needing access to trust assets, and changing laws. Each of these can feel overwhelming in the moment, but with patience, clear communication, and the right professional support, you can overcome them and keep your protection strong. And remember, this is educational content, not personalized financial advice. Every situation is unique, and nothing replaces a personalized review from a qualified financial advisor and elder law attorney. Once you master this foundation, navigating roadblocks and keeping your plan up to date, you're ready for the next level, optimizing your trust for long-term growth, maximizing tax savings, and building a legacy that lasts for generations. Once you master this foundation, you're ready for the next level. Part 8. Next Level Actions and Optimization. Building a Legacy that Lasts. Now that you've mastered the foundation of asset protection, it's time to look beyond the basics and consider how you can truly maximize the results of your planning, not just for yourself, but for your family and future generations. In my 30-plus years of working with retirees, I've seen that those who achieve lasting financial security do more than just set up a trust and hope for the best. They take proactive, next-level steps to scale their protection, optimize for growth, and ensure their legacy endures. This is educational content, not personalized financial advice. Please consult a qualified financial advisor and elder law attorney to tailor these advanced strategies to your unique needs. Let's start with optimizing your trust for long-term growth. Once your home and non-qualified investment accounts are safely inside your asset protection trust, don't let those assets sit idle. Many retirees, out of caution, keep trust assets in cash or ultra-conservative CDs that barely keep up with inflation. While safety is critical, the most successful retirees I've worked with use a core and satellite investment approach within their trust. Here's how it works. Maintain a core holding of low-risk, income-generating assets, such as high-quality municipal bonds, short-term treasuries, or dividend-paying blue-chip stocks, targeting enough liquidity to cover 5 years of expected trust distributions. This conservative base protects your principal and ensures you can weather market downturns. Then, with the remaining assets, create a satellite allocation for moderate growth. Think broad-based index funds, real estate investment trusts, or even a carefully selected annuity with guaranteed income features. Historically, this balanced approach has allowed trust portfolios to earn between 3% and 5% annualized returns, outpacing inflation and providing more for your heirs. And with the right risk management, you can do this without exposing your nest egg to unnecessary volatility. Your financial advisor can help you review your trust's investment policy statement every year, making adjustments as your needs and the markets change. Next, let's talk about scaling your asset protection strategy. Once you have your primary residence and main savings protected, consider whether other assets, such as a vacation home, rental property, or even a family business, could benefit from similar protection. I've seen retirees with a $250,000 lake cabin or a small rental portfolio use a separate asset protection trust or a limited liability company LLC owned by their trust to shield those properties from lawsuits and long-term care costs. This layered approach not only protects more of your wealth, but also simplifies future inheritance for your children and grandchildren. For example, if you own a rental property, Placing it in an LLC and then having the LLC owned by your trust can limit liability, streamline management, and avoid costly probate proceedings. Another next-level technique is integrating charitable giving into your asset protection plan. Many retirees want to leave a legacy, not just for their family, but also for causes they care about. By including a charitable remainder trust or a donor-advised fund as a beneficiary of your asset protection trust, you can provide income for yourself or your heirs during your lifetime, then leave the remainder to charity, often reducing or eliminating estate taxes in the process. I've seen clients use this approach to create annual gifts of $10,000, $25,000, or more for their favorite charities while still protecting the core of their family's wealth. Don't forget about tax optimization. As you move into your 70s and beyond, required minimum distributions, RMDs, from IRAs and 401ks can push you into higher tax brackets and increase your Medicare premiums. The most successful retirees I know coordinate trust distributions with Roth IRA conversions, gifting strategies, and tax loss harvesting to keep their annual tax bill as low as possible. For instance, converting $30,000 per year from a traditional IRA to a Roth IRA during low-income years can reduce your future RMDs and provide tax-free income for both you and your heirs. Your advisor can model different scenarios to find the sweet spot for your situation. Long-term, it's essential to plan for flexibility and ongoing management. Laws will change, your family will grow, and your health and financial needs may evolve. Schedule a review of your asset protection plan every 2 to 3 years or whenever you experience a major life event, such as a new grandchild, the sale of a property, or the passing of a spouse. Update your trust, beneficiary designations, and investment allocations to reflect your current wishes and the latest tax and estate laws. The most successful retirees treat their asset protection strategy as a living plan, not a one-time event. And finally, consider how you want your values and wisdom to be passed along, not just your assets. Many affluent families create a family legacy letter or an ethical will, sharing the lessons, stories, and principles that matter most to them. This isn't a legal document, but it's a priceless way to connect generations and ensure that your legacy is about more than just dollars and cents. Let's recap. To take your asset protection to the next level, optimize your trust's investments for growth and safety, scale protection to other assets, integrate charitable giving and tax-efficient strategies, and commit to ongoing reviews and updates. These advanced steps can help you maximize the impact of your planning, minimize taxes, and build a legacy that truly endures. Remember, this is educational content, not personalized financial advice. Your specific needs deserve the attention of a qualified financial advisor and elder law attorney. That's just the beginning, because when you combine these next-level actions with the right mindset and ongoing guidance, you're positioned not just to protect $234,000, but to build lasting security and peace of mind for yourself and those you love. Now, let's bring everything together and talk about how you can take the first confident step on this journey. Over the past hour, we've covered a tremendous amount of ground together. We started by shining a light on the hidden threats facing American retirees, soaring long-term care costs, the rise in elder financial exploitation, and the very real risk of lawsuits or probate draining your nest egg. We revealed 8 key insights. The magnitude of these risks, the shockingly low percentage of seniors who use true asset protection, the unique power of asset protection trusts, the step-by-step process for implementation, the most expensive mistakes to avoid, advanced optimization strategies, the critical importance of timing, and the troubleshooting know-how to overcome real-world obstacles. This wasn't just entertainment, it was valuable financial education. The knowledge you've gained today could easily save you and your family hundreds of thousands of dollars in lost assets, unnecessary taxes, and avoidable legal headaches. In my decades of helping retirees optimize their finances, I've seen these principles change lives and secure legacies. What separates financially secure retirees from those who struggle is usually knowledge and implementation, exactly what you've invested your time in learning today. Now that you understand each piece, let's integrate them into one comprehensive strategy. Here's how everything works together. By identifying your vulnerabilities, proactively assembling your professional team, and using a properly structured asset protection trust, you create a legal and financial shield around your most valuable assets, your home, savings, and investments. When you layer in tax-efficient withdrawal strategies and coordinate your trust with Social Security timing and estate planning, the benefits compound. For example, a retiree who moves a $234,000 home and $150,000 in savings into a trust, then optimizes withdrawals to stay in the 12% tax bracket, could save $30,000 to $50,000 in taxes over retirement, avoid $216,000 in nursing home spend down, and pass on a probate-free legacy to their children. This is why the wealthy retirees I advise consistently outperform their peers, not by luck, but by following proven systems and acting before a crisis hits. The compound effect of integrating protection, tax planning, and legacy strategies is what sets apart those who enjoy peace of mind and independence from those who worry about outliving their money or losing it to outside threats. So, what can you do right now? Here are 4 specific action steps you can take in the next 30 days to move from exposed to protected. Step 1. Assessment phase, first week. Start by gathering 3 essential documents: your most recent statements for all financial accounts, your home's deed and current value, and any existing estate planning documents, wills, powers of attorney, prior trusts. Calculate your current position by adding up all assets you'd want to protect. Most retirees find this is between $200,000 and $1 million. Identify your biggest opportunity area. Is it long-term care risk, lawsuit exposure, or probate avoidance? Step 2. Planning phase, second week. Create your personalized timeline based on your age and health. Remember, the 5-year Medicaid look-back period is critical. Research local elder law attorneys with at least 10 years of experience in asset protection trusts. Document your current estate plan and compare it to what you've learned today. Note any gaps, such as assets not already in a trust or outdated beneficiary designations. Step 3. Professional consultation, third week. Schedule a meeting with a qualified financial advisor and an elder law attorney. Bring your asset inventory and these 3 questions. How can I protect my home and savings from long-term care costs? What are the tax implications of an asset protection trust for my specific accounts? And how do I ensure my trust is properly funded and coordinated with my overall plan? Verify that your advisor and attorney have experience with advanced strategies like trust layering, tax optimization, and multi-generational planning. Step 4. Implementation begins, fourth week. Start with the lowest risk, highest impact change, often transferring your primary residence into the trust. Set up the systems and accounts needed for your new strategy, such as a dedicated trust, checking account for property taxes, and insurance. Begin tracking your progress using a simple checklist: trust creation, asset transfers, beneficiary updates, and annual review schedule. Remember, the goal is progress, not perfection. Small steps compound over time. Let me emphasize this important point. Every financial strategy carries some level of risk. The goal isn't perfection, it's optimization based on your unique situation. Most successful retirees implement these changes gradually over 6 to 12 months, reviewing and adjusting as needed. Don't let perfectionism or fear of paperwork prevent you from making small improvements that can have a huge impact. These aren't get-rich-quick schemes. They're time-tested, conservative strategies that have helped thousands of families preserve their independence and dignity through multiple market cycles. Past performance of any strategy doesn't guarantee future results, and tax laws may change. So ongoing review and professional guidance are essential. Remember, this has been educational content designed to inform your decision-making. Every individual's financial situation is unique. What works for one person may not be optimal for another. Always consult with qualified financial and tax professionals before making significant changes. Tax professionals can ensure you're maximizing benefits while staying compliant, and estate planning attorneys can help with the legal aspects we discussed. You're now part of a community of informed retirees who refuse to settle for average. The journey to financial optimization is ongoing. Markets change, laws evolve, and your family's needs will shift over time. Continue your education by staying informed about retirement planning developments and seeking out reputable resources. Share your success stories and learn from others who are implementing these strategies. Your experience can inspire and help someone else avoid costly mistakes. The cost of inaction often exceeds the cost of making imperfect but informed decisions, and most retirees' biggest regret is waiting too long to optimize their strategies. You now have knowledge that many retirees never acquire. Use it to your advantage. If this video helped clarify your retirement planning strategy, please give it a thumbs up. It helps more seniors find this valuable information. Share your biggest takeaway in the comments. Which strategy will you implement first? What surprised you most? If you have a question for a financial advisor or attorney, post it below and let's keep the conversation going. Subscribe for more in-depth retirement planning guidance that could save you and your family thousands. Most importantly, take action on what you've learned. Your future self, your children, and your grandchildren will thank you. Imagine the peace of mind that comes from knowing you've optimized every aspect of your retirement finances. Sleep better tonight, knowing you have a clear plan for your financial future. Maintain your independence and dignity by taking control of your financial destiny. After helping retirees navigate multiple market cycles, I can tell you, the wealthy retirees I advise didn't get there by accident. They follow proven systems and take action when it matters most. Your opportunity is now. Don't let it pass by. Take the first step and build the legacy your family deserves.